Ready? Nope. No, not yet. 30 seconds.
Yeah, hang tight. So it's a little delay on YouTube. At 59.
Good.
And if you want, but yeah, nothing's running.
All right, we're good to go. Okay. 6 p.m. We'll call the meeting to order, please. This is the Burnett County Board of Adjustment. May we have the notice posted in accordance as far as the open meeting law? A copy thereof.
Minute 5:19, I have your report. Is valid, Class C, and negative.
It was posted correctly, because I actually did verify it. I did not have to read them again. There we go. Okay, notice of publication so noted. Thank you. Okay, we have the secretary read the notice of the public hearing, please.
Notice of public hearing, State of Wisconsin, Burnett County, Monday, September 20th, 2021 at 6 p.m. at the Burnett County Government Center in room 165, Town of Neenan, Siren, Wisconsin, regarding the following. A variance 2123 Kelmo is withdrawn. Second agenda item is appeal 2101 Kelmo. Public notice is hereby given to all persons in the town of Neenan, Burnett County, Wisconsin, that Daniel Kimo has made an application to appeal the decision made by the Land Use and Information Committee in reference to conditional use permit CUP 2109 located at 27060 State Road 35 in a A2 zoning district in the southeast quarter of the northwest quarter and the southwest quarter of the northwest quarter of Section 4 T39N R16W. Appeal 2102 Helmo. Please notice it is hereby given that all persons in the town of Neenan and Oakland, Burnett County, Wisconsin, that Daniel Kimmel has made an application to appeal the decision made by the Land Use and Information Committee in reference to conditional use permit CUP 2108 located at 7162 South Devils Lake Drive in RR1 and A2 zoning districts in the northeast quarter of the northwest quarter and government lot 1 of Section 4, Town 39 North, R16 West, and government lot 4 of Town 33, of Section 33, Town 40 North, and R16 West. Appeal 2103, Webb Lake Area Concerned Citizens. Public notice is hereby given to all persons in the town of Webb Lake, Burnett County, Wisconsin, that the Webb Lake Area of Concerned Citizens have made an application to appeal the decision made by the Land Use and Information Committee in reference to conditional use permit CUP 21-14 located at State Road 77 and Deer Lake Road, 30928 Deer Lake Road on Jones Creek in the C1 zoning district parcel in the south one half of the south one half of the northwest quarter of the southeast quarter, lot 1, CSM, volume 28, page 42, section 18, town 41 North, R14 West.
All right, thank you. May we have an approval, a motion for the approval of the agenda order, please?
I make a motion to approve the agenda as written.
I second the motion. All in favor signify by saying aye.
Aye.
Aye, opposed, same sign. Thank you. We have a little meeting procedure here we have to go through. All public comments, there's a 3-minute time limit, only one person speak at a time. Please state your name and address and reason for your comments. Board shall ask for public comments not related to the variance/appeal at this hearing. Board shall ask that one person from the announced variance/appeal be designated by the applicant to present your case before the board. Board shall then ask for public comments and any received correspondence from local authorities or neighbors concerning the particular variance/appeal. After initial presentation, questions for the board shall close the public part of the meeting, deliberate amongst themselves, asking any questions to clarify items of concern. A vote will be taken before moving on to the next variance or appeal on the item or agenda. Important, please note. Applicant, local officials, and DNR shall receive within 30 days a letter summarizing the hearing, also including information on the applicant's rights to appeal the decision to the circuit court within 30 days. Any person aggrieved by this decision or any taxpayer or any officer, department, board, review, or bureau of the county may within 30 days after filing of the decision in the Office of the Board of Adjustment commence an action in the circuit court seeking the remedy available by certiorari. Thank you. Okay. At that point, we will take up the appeal 2101, Chelmo.
If they're all online, so we just gotta get them turned on here real quick.
And Mr. Chalmers should be on.
Hello, this is Daniel Chelmo.
Yeah, we can hear you.
Okay.
I'm asking that my agent, my attorney, Lee Troni, will make the presentation on my behalf.
All right, sir.
Okay, Lee, you should be turned on.
Hello, can you hear me?
Yep.
Well, good evening, members of the Board of Adjustment, and I'm sure other personnel from the county are there. My name is Lee Taroni. I'm an attorney in Wisconsin, and I represent Daniel Chelmo on his applications, the first one here tonight and also the second one here tonight. They're quite similar in legal terms in some ways, but first I just want to cover a bit of ground. I submit things to you, and I generally get an acknowledgement that it's been received, but I'm just going to, for sake of the record, say what I submitted so we can all be sure that everything I put in at least got in, okay? Relevant to this appeal would be a Land Use and Information Committee packet and also their decision and minutes on that application dated April 6th, 2021. Then followed a application to the Board of Adjustment for appeal and a supporting letter that I wrote, both dated June 2nd, 2021. And then lately I followed that up with some written comments for the record dated September 10th, 2021, and some follow-up emails on September 17th and 20th, 2021. I trust those are all in there.
I believe so.
Yeah.
And I just recite that to make sure that the facts and laws that I submitted have been submitted. There may remain some arguments upon those, especially the laws, but just to be clear, that is everything that I submitted, I believe.
Yes, sir.
I wasn't sure, and I ask in part because I wasn't sure, are we doing this like the previous one did not occur? Just go through everything again?
That's what our corp counsel told us to do for the most part.
Okay. Okay, I didn't hear back on that question, so that's why I asked. So, with the facts and law in, the appeal is of the decision that was rendered by the committee on April 6, 2021. And in doing so, in that motion, they state specific reasons that they underlie that motion to deny the permit. And so the letter that I wrote on June 2nd, 2021, goes through some basic law, but then I go through specific legal arguments about each one of those things that was cited, because each one of those, I think, is a legal error, and that's the reason for the appeal. The first thing was, it goes right in order. Conflict with a comprehensive plan. It says right in the statute that you cannot use a comprehensive plan to deny a conditional use permit, which was the matter at hand. Also, I believe it's stated that a town comprehensive plan is cited as the basis for denial, and that wouldn't be legal in this case either, because we're talking about county administered zoning. And there is a good case on this. It may not be in my materials, but I found it since. It's the M&I Bank, Marshall and Ilsley versus Town of Summers case. And that has a citation of right, I'll find it in just a second here. I don't think this case was in my materials before, so I want to add it in now. And the citation is 141 Wisconsin 2nd 271. Also 414 Northwest 2nd 824. This is a state Supreme Court case where a private party attempted to sue a town for a zoning decision it made as an input into what the county's decision was, because this was a town under county zoning. And the private party sued the town but not the county. And that motion was dismissed on the basis of the legal reasoning by a state Supreme Court that when it's county administered zoning, that's the only party that's really responsible for it, not the town, even if the town is trying to provide input into that county zoning. And that was a case about who's responsible for that zoning decision. That would be another citation. The comprehensive plan by anyone but the county really wouldn't work. And then within the statute itself, again, it would only be the county plan, not a town plan. But it also says in the statute that you don't use it to deny conditional use permits. So I think that's an incorrect legal basis. Incompatible with the zoning. I believe this decision point is a misunderstanding of zoning law. You have a zoning classification, and within it are permitted uses and conditional uses. And as the statute or the ordinance is already written, that's what's in it. To make an argument that a allowable or conditional use is somehow not allowed in that district belies the whole point of zoning. That district is defined. The types of uses that are available are defined, and this one that was applied for is defined as something that you can apply for. To say it's not even possible to have it in that district is just simply legally incorrect. That would be an incorrect basis to use the district that it's allowed in to say that it's not allowed. It doesn't really work that way. Public health, safety, welfare. There's a case, I cite to it in the letter, the Heartland case. You cannot generically cite public health, safety, welfare like the motion by the committee. You have to state what is the problem and why it applies to that certain issue. You can't just say magic words like that and have a legal basis. They state lack of a driveway. However, it's in the record evidence that there is a driveway access. An application was being made for that to be altered as necessary. But when they say there's no driveway and there, as a matter of fact, is a driveway, that's an error. If there was something wrong with the driveway that they didn't like, they could have specified that, but it's not specified in the evidence. Anyway, upon approval of a permit, you usually proceed with your application to modify a driveway accordingly. Not a lot of people build infrastructure and just wait to see if they get a permit later. Cart before the horse. Character and density, this is the same thing as the A2 argument. Those are zoning terms. It's not a reason to say that it doesn't apply in that jurisdiction, that zoning district. You have to recall that personal preferences or speculation are not substantial evidence, which is what's key in these decisions. I believe there's testimony about someone saying they like the view the way that it is now, and they don't think that the view should change. But when we buy our properties, we don't get to usually buy the view around them. That's usually not included in the property. Zoning is a reasonable land use restriction for everyone involved, but a landowner is a landowner. And just a personal preference without more or speculation about future pitfalls really doesn't play into a zoning decision. Next is this opinion by the town of Meenen. That town in particular has no land use controls whatsoever. They wouldn't really have a legal basis to have a legal opinion of weight. Even if they did, as we mentioned earlier on, especially with the Marshall and Ilsley case, the M&I Bank case, it's really not a factor in how the county administers its zoning. Certainly not in this case where there's no county ordinance saying that you're beholden to whatever a town says. That's just not how the statutes work. Again, that's in the case law. And similar with the Village of Webster opinion, they base it on extraterritorial zoning, whereas they don't have any and never have had any. Extraterritorial zoning is something that's possible for a village to have. They have to adopt certain ordinances to make that exist, and you're not exercising it if you don't adopt those ordinances. They've never had them. It would be a legal error to base it on a mere opinion without any legal basis for why that would be a regulatory decision. These land use property decisions are not popularity contests. The legalities are laid out in the law, and if someone is fine with the law, they're supposed to be able to go on their way and do what they can do. My client's contention is that's not exactly what happened here, hence the appeal for the legal reasons, as I noted. I mentioned the other facts and such are all on the record, and happy to take any questions.
Going back to your Town of Oakland comprehensive plan in the year 2040.
Well, that wasn't cited for this appeal. It's not part of the motion decision, and so it wasn't part of what I wrote about as a basis for appeal.
Okay.
This was only Town of Meenen.
Okay. Pardon me on that one.
I don't have any questions.
Good.
No, I don't have any.
Oh, okay.
So this wasn't a permit that was granted subject to conditions. We're not negotiating or debating conditions. It's just a straight denial. There's not a lot of facts other than why I recited the things at the beginning. I think that's just about all the facts that are in the record. And these were the legal reasons that were cited. And the appeal, again, is just based on, I think those are incorrect in a legal sense. And I tried to lay that out why. So that's the appeal. And I can keep talking if the members want.
Okay.
I don't, okay, interrupt me at your will. In this position, we're asking you to overturn a decision that was made below. And if there's not enough in the record to sustain that decision, that's why we appealed and we think it should be overturned. If the materials aren't there in the record, it's an appeal of the record. And if it's just not there, then that's why we argue the decision shouldn't stand as it is. The committee has options. You can approve of what happened below. You can do a remand where you send it back and tell them to do a do-over because you don't have enough to decide. Or we would argue for overturning it entirely. So, of course, as the applicant, we argued to have that decision overturned.
Great, thank you. It is hard for us to say the amount of input that they had that we don't have, okay? They've had several meetings where the committee met with selected members from the sheriff people, the county, the state in some cases as far as permits. We don't have that information that they had. And trying to reason how they did it, quite honestly, is beyond me because we don't know what they were thinking or what input they had to make their decisions upon. And being the points that you brought out, I read your letter. Here we've got a stack of 4 or 5 inches here of papers back and forth. On both views, your view and the view of the county or the land use committee. Number one, we respect these people because we've known them for a long time. And not saying that they're right or wrong all the time, but that isn't the point. The point is they had information that we didn't have. And maybe it would be best at this point in time that this decision be turned back to them with the bullet points that were made to reassess the way they handled this. What's your feeling on that, Jeremy?
It's definitely one of our options, as you state. This is, like I said, is legal precedent. Lee presented a case that says, and I've read it many times, in the minutes from the Land Use and Information Committee, their reasons to deny. He has a one-sided legal argument stating that he has a bullet point for every one of those, stating that that would be the case. I'm inclined to agree with that and let it be said. I know Lee and have had conversations with him when he worked with the Towns Association. So I just, as a character standpoint, I've talked to Lee over the past, never about any of this stuff. But he did work for the Towns Associations for years, representing the towns in government issues like this. I've stated before, every day in court, one attorney is right and one is wrong on the same legal law. So that doesn't mean a precedent. I say that's above my pay grade for understanding interpretation of statute. But the reasons for motion denial are listed in our minutes, and we've been brought information contradictory to the logic that would be there. If the committee wants to go back and address those specific issues specifically, that's definitely an option. Yeah, this is complicated.
Absolutely.
As one of the options here, like I said, are you making a motion to send it back to land use committee, or you're just throwing?
That would be one of my, they seem to lean on some points that, again, according to somebody's right, somebody's wrong. But I still think they had more information than we do.
Well, yeah. Not being at the meeting,
Right.
but that's public record, the information, so we have the minutes of the meetings and proceedings
Yeah.
that are there. I think, like I said, our task is to look at the issue and see whether or not, there was information. I've never sent, I think we said we've had one precedent where we sent committee back, or a case back to, you don't mind?
I think so. Well, Marvin's been on this board forever. You probably remember how many.
I've only been on for a few months, people.
Yeah.
Learning quickly. And again, we're still in the beginning process of public comments too. Right. If I'm not,
Yeah, the,
our,
signed up haven't spoken.
our assessment should probably, if that's an option, we'd probably do that towards the end. Would that be more of a proper precedent with them?
Yeah, you still have to let all the other.
Correct, okay.
Yep.
I know we have public comment, certainly, the email's been forwarded, and, whatever. We should check, see at the meeting if there's some public comment, or somebody wants to make in person.
Yeah, I think we've got, what, 8 people, I think, roughly signed up that want to speak.
And is Lee still on there?
I'm still here, but trying to not speak unless spoken to, respectfully.
Understood.
So should we start going through the list of speakers in order that they signed up?
Yeah, I would guess that's fine, as long as Lee, if you have any further comments on behalf of your clients that you want to address at this time before we move on, if I don't know if we have to go back.
You can always ask
Yep.
questions.
At the end, okay. Perfect.
So I will mute these and we'll start with public comment.
Yes, please. That would be Donald Hamilton. Please, if you would, yeah.
Good evening. Thank you for your service. Don Hamilton, a full-time resident, town of Oakland. I also sit on the Oakland Land Use Planning Committee. As a full-time resident in the town of Oakland, I support the decision made by the LUIC to deny this permit. They denied it in a fair way. They followed the rules, the policies, procedures to reach a decision. They considered and fairly weighed all the evidence presented and followed the applicable rules to reach a decision. The LUIC correctly determined that 2109 was incompatible with the purpose of an A2 zoning district, and 2109 was denied. Please reaffirm their decision by denying 2101. The applicant does have, by law, a certiorari appeal to a circuit court judge. And if there are any questions about the administrative legalities of this decision, I would highly recommend you do not remand, that you affirm this decision. The applicant, as well as those that are opposed to this decision, have the right to a circuit court judge reviewing this case for administrative error. And I would encourage you to allow that remedy to be sought by the applicant or by the people who may oppose this decision tonight. I do want to correct Mr. Chalmo's counsel that a town comprehensive plan was used to deny this permit. It was not. The Burnett County comprehensive plan was cited as a reason. The town of Meehan does not have a comprehensive plan, so that's an incorrect statement. And counsel has really oversimplified in his legal argument this idea of incompatibility with the zoning district. It's way more to that, and it's involved in the zoning ordinance. The Webster letter also, the Webster letter never said they were exercising their extraterritorial authority. The Webster letter said it was incompatible with their comprehensive plan because it was adjacent to their residential district. And as far as municipalities being allowed to weigh in, Burnett County signed their comprehensive plan in 2010, Ordinance 2010-03. They formally adopted the Burnett County Comprehensive Plan into Chapter 30. It's Section 30-5. The comprehensive plan and CUPs are a part of the ordinance. The comprehensive plan piece, the consistency requirement, is in the statute. It's on page 323 in the 1999 Wisconsin Act 9 Smart Growth Law. That law requires these zoning ordinances to be consistent with the plan. Our conditional use permit process exists solely, lives and breathes within Chapter 30, within the zoning ordinance. And zoning ordinances by law have to be consistent with the comprehensive plan. So there's a lot of context and legalities here. Look, I'm not a lawyer. I'm just a retired guy living on Devil's Lake. But I can read. And the law is clear, and you can misapply and misinterpret an argument without giving you the clear picture. So please do not remand. Please affirm their decision. Thank you for your time.
Sue Hamilton.
Good evening. My name is Sue Hamilton, and I am a full-time resident of Webster and live at 7158 South Devils Lake Drive. Please reaffirm the LUIC's decision to deny Appeal 21-01. The committee fairly determined there was substantial evidence to disapprove CUP 2109. The committee looked at all of the evidence from the applicant, the towns of Meehan and Oakland, and the village of Webster, as well as from the public. After a thorough discussion, they determined CUP 2109 would have a negative impact on the health, safety, welfare of the neighbors and surrounding property, including a negative economic impact as well. The committee determined this CUP conflicted with the Burnett County Comprehensive Plan and was not compatible with Chapter 30 purpose of A2 zoning district for density and intensity of use. The committee followed the rules, the policies, and weighed all of the evidence presented and followed the applicable rules to reach this decision. Please uphold the committee's decision by denying this appeal. Thank you.
Thank you. Jerry Kraus.
Hello, good evening. My name is Jerry Krause. I live at 6720 Hayden Lake Road in rural Danbury, Oakland Township on Lake Minerva. I sent a letter to the committee through Jason the other day. I don't want to recite all of that, and it's somewhat cumulative of what you've already heard. But I would certainly urge you to deny this appeal. It's a 90-unit campground. If you've driven by, I know the applicant has talked about his counsel again this evening about the fact that there is a driveway there. If you've not been by it, you'll see it's a somewhat of a grassy bit of a driveway with a gate on it the way it appears onto State Highway 35. As the minutes of the committee that heard this the initial application for the CUP is that they found there wasn't access. It's still very unresolved. They indicated there would have to be turn lanes. There's no such thing out there on State Highway 35. It seems very premature to somehow grant the CUP. I like the prior speaker. Also, don't remand this. You can certainly affirm there's plenty of record that would indicate substantial evidence of compliance by the committee in reaching its decision to deny the CUP. Thank you so much, and again, for your service.
Thank you. Rose Catapano?
Thank you for the opportunity to speak. My name is Rose Catapano, and I am a taxpayer of Burnett County. I own a cabin on 7154 South Devils Lake Drive. I support the decision made by the Burnett County Land Use and Information Committee to deny this CUP. The committee properly considered all the facts presented and appropriately determined that this CUP did not meet the requirements and that this CUP conflicted with the Burnett County Comprehensive Plan. At the meeting, the public presented substantial evidence that this CUP would have a negative impact on the health, safety, welfare of the neighbors and surrounding property. The committee's decision to deny CUP 2109 was appropriate. The committee followed the rules, policies, and procedures, weighed all the evidence presented, and applied the rules appropriately to make their decision. They determined that CUP 2109 was incompatible with Chapter 30's purpose of A2 zoning district for density and intensity of use, and CUP 2109 was appropriately denied. Please reaffirm the committee's decision by denying Appeal 2101. Thank you for your time.
Thank you, Rose. Greg Whitaker? Oh, I'm sorry.
Online? Okay, go ahead.
Hello, this is Greg Whitaker, Village of Webster residents. I would just reaffirm that the LUIC did act accordingly in denying CUP 2109. We listened to the applicant's legal advisor's very one-sided argument. I wanted to remind you that just because something is an acceptable conditional use doesn't mean that it is appropriate, and that's in the legal language for approval for every time and place. And this was determined by substantial evidence that this is not appropriate given concerns, substantial concerns for health, welfare, environment. Municipalities, I believe, can and should work together and weigh in so that we have intergovernmental communication, and they saw substantial conflict with their comprehensive plans. And so I would also ask you to please reaffirm the LUIC's decision to deny this CUP, and I will thank you for your time.
Thank you. Christina Whitaker?
Full-time resident on the Yellow River. just south of the proposed campground, and I'm calling today to support the Burnett County Land Use Committee's decision to deny the Chamo Cup 21-09. The April 6, 2021 land use meeting accurately reflected the proposed cup conflicted with the Burnett County Comprehensive Land Use Plan and was not compatible with the intended use statement of the A2 zoning district. The denial reflected the evidence-based concerns that the CUP presented and how it would have a negative impact on the health, welfare, and safety of the neighboring lands and waters. The Village of Webster, Townships of Meehan and Oakland all opposed CUP 21-09, reiterating the concerns of the public and the Land Use Committee's decision. The committee determined the proposed CUP was incompatible with the purpose for A2 zoning, and the applicant failed to meet the necessary categories that a CUP requires. The record is clear, and we're asking again that you affirm the committee's decision to deny CUP 21-09 by denying Chamo Appeal 21-01. The committee carefully weighed and applied the proper protocol with all the evidence presented for this proposed CUP before making a decision. The committee fairly determined there was substantial evidence to warrant denial due to the unique problems this CUP presents at this particular location. Thank you for your time and consideration.
Thank you. Kim Stoffel?
I hung up when I was again. Thanks for your time, guys. I represent myself as well as concerned citizens of Devils Lake. We support the decision by the Land Use Committee to deny the original CUP. And it's, all the input was considered, facts were considered, and it was appropriately determined that the CUP did not meet the requirements. It conflicted with the Burnett County Comprehensive Plan. It's incompatible with the purposes of the A2 zoning district. The applicant failed to provide any evidence that the CUP would not negatively impact health, safety, and the welfare of the neighbors and the surrounding property, which can be taken into account, contrary to the counselors of Kelmo's, his counsel saying that it doesn't have to be taken into account. It can be taken into account. So the Land Use Committee there was substantial evidence presented by the public, and the public thoroughly discussed the negative impact for that health, safety, welfare of the neighbors, including the negative impact that was considered as well. Even the towns of Meehan, Oakland, and the Village of Webster provided evidence to oppose this. So, Elmo's attorney tried to say that he, as you saw, he glossed over everything, and he tried to downplay all the evidence that the Land Use Committee said why they denied it. He kind of downplayed it and pushed it off to the side like it was generic information. We were all there on that call and in that meeting, and there's a lot of evidence presented to say why this should be denied, and it was good evidence. So don't let, Kelmo's attorney downplay it and pretend it was just generic information that shouldn't be applied. So please deny this appeal, as the Land Use Committee was appropriately denying it in the first place. Thank you for your time.
Thank you.
So that should be all the people that were signed up. Is there anybody that didn't sign up that still wants to speak on this one in the room?
Okay.
Nope.
Seeing none, we'll go to Mr. Chelmel's representative.
Thank you, I'm still here. Just to reiterate, 66.1001, subsection 2M, effect of enactment of a comprehensive plan on consistency requirements. Comprehensive plan is not itself by regulation. That means it is not something, it's not a regulatory tool. Okay, zoning is. Zoning is a regulatory tool. And then in section B under there, it says a conditional use permit that may be issued does not need to be consistent with the political subdivision's comprehensive plan. So it doesn't matter which plan they were talking about, citing that blanket reason is not something specific. And this is part of the issue you have with the decision in front of you that you're being asked to review. It does not use specifics. And they have to cite specifics in the conditional use permit statute to underlie each of those bases. And there's a driveway, well, but what about the driveway? Nothing is said, so it's just not apparent, et cetera, et cetera. And that's part of the basis for it. If the record's not good enough for you to be sure, how do you expect that the record is good enough for a judge to be sure any more than you? I mean, you're a lot closer to the situation than a judge is. I kind of disagree with that. Just send it to court. Court's very expensive, and we can solve these issues on our own. Opinion is just an opinion. Whether it's a town, a village, if there's not a legal weight behind it, a regulatory authority, it's an opinion. And everyone's welcome to their opinion, even a local governmental unit. But it needs to be recognized for what it is, if that's all it is. It's just an opinion. I think there's a fundamental misunderstanding here. There's nothing that prevented the opposition to Mr. Chelmo's applications from showing up and presenting evidence on the other side. We've heard public comment that's supposed to trigger some sort of hunt for evidence, but never the evidence itself. And that's what I included those minutes from the campground workroom to demonstrate. There's people with evidence who could have been asked to be there, and they're not. And when you read the minutes, it sounds like they come down the exact opposite of what you hear from public comment. And that should be an indication that you can't take hearsay public comment for being the truth of a matter. It's not. These are legal conclusions, and yeah, it is one-sided. But again, nothing prevented the opposition from hiring an attorney to present a valid argument if there is one. And this is what it is. I don't think there are any. And that's why I brought this appeal and why I've argued it. And I'm not hiding any arguments. I'm showing all the cards. Can anyone show up and dispute this law versus that law? I cite everyone in there. I refer to the cases. But no one has shown up to do that. So I don't know how you uphold that decision by the committee. That would be my...
Thank you. Is there any other input at all, Jason, from the county, townships, anything recent that came in that we didn't get?
No, you have everything. There was nothing specific that I recall from a township.
Okay, thank you.
On the appeal.
Thank you. If that's the case, we'll close the open part of the meeting, and board members here will deliberate. I might add that board members here visited or do visit all sites, so what are your thoughts on this, Jeremy?
My thoughts are it's not easy. I think that like I said, the attorney states some questions as to the reasoning that was specific in the motion to deny, that address some legal aspects. Again, saying that, lawyers win and lose every day. It's not in my position there. I do disagree a little bit with Lee on, well, I shouldn't say I disagree. Town and village input does not have a legal standing when you come to zoning, when you are county zoned. We've always been on the county board for a few years and land use and information like that. We've always had the opinion that it is highly reasonable to accept the opinion of the town and try to follow that in any zoning issues. I personally like to say local influence and stuff, which is not a legal right, say the town of Anderson, to argue whether they're in favor of some conditional use permit in the area. But the board has always been forthright in listening to the local municipalities and taking their opinion as something. Whether there's a legal weight to it is a different issue, but that has been something as a precedent we've kind of said.
You can say that for this board too, because
Correct.
we asked for input and paid attention to it, certainly.
And with the Village of Webster and the town of Meehan in opposition to it, is a big issue as a secondary determination in the case. So that's,
I guess,
a little bit.
I guess the thing that bothers me a little bit is the generalization saying, well, it's bad for the whatever, the county or whatever it is, but they don't come up with specific reasons why they made that decision, and they don't put them out. For instance, the thing with the road, well, so what about the road or whatever, but whether that's enough to send it back, I don't really know.
Jason, what? Do you have any input on the county's behalf in this? You want to double check? No. Okay, thanks for your clarification.
Right. Was there ever an attempt at rezoning any of this area?
No.
Okay.
Marv is tough. Process is not easy.
No, it's not.
And there's no correspondence or information from the county's attorney specific to the case.
Correct.
Correct.
I personally would feel much better if, as I said before, if I had somebody stating the reason why it would be bad to affect the health and welfare of the community with specific reasons. rather than just your generalization, and that stuff bothers me. Blanket statements don't really do much.
And that's understandable. In these situations, you never will have people agree. The fact is, does the gentleman have a right to do a campground on the site?
Okay.
Conditional use permits we've done that over time for years for campgrounds. Now, the county does have, I believe, a moratorium going on future campgrounds, correct?
Yeah, that doesn't impact.
This is already applied previously, so it's irrelevant to the thing, but from a perspective that way. Again, the opinion is there, but the legitimate arguments to me has been made through the legal. The county chose not to have legal presentation to argue with it. And I'm no attorney, but I know when most people show up in court and if the other party isn't there, it's usually not a good thing for them in most cases. Not that, you know what I mean?
Yeah, certainly.
But that's the big thing that bugs me is the village and the town of Meehan in opposition to the thing. Again, I am under my understanding that that's an opinion. It's not a legal precedent or anything that's statutory or factual, but we've always taken that, or in past experience, I should say, this board is to look at the facts presented about the conditional use permit and whether or not it was done properly. It'd be nice to have a third member, wouldn't it, Marta?
Well, I'm still not comfortable with generalities, making statements.
Does that swaying you one way or the other, or would no?
Well, what I'm saying is, again, health and welfare or safety or overloading medical or whatever we're doing, but nobody's saying, we've got 24 ambulances or we've got.
Burnett County has a population of 15,000 and swells to 40,000. Our EMS services are designed for 15. We have that situation all throughout. Again,
but it's not stated, it's not brought out the fact that this is the reason we feel comfortable.
I don't recall. Do you remember reading the Village of Webster's letters and there was correspondence about conflict of interest and things like that? You remember reading through some of that? Which is, again, above pay grade.
I don't know.
Quite a conundrum, Marv.
Well,
Well, what are our options? Approve, deny, or send back, right?
that's where we are. We've got three decisions. I think we're missing some information, but that's,
I try to take the emotion out of it, of people, neighbors, things like that. The gentleman applied for a conditional use that has been approved many times in the past at certain aspects throughout
Yeah.
the time. There was a significant input at committee meetings, which has happened over time.
Sure.
But the facts of the matters are, we're here to make a decision on whether that decision by Land Use and Information Committee was based on the best of their knowledge. If you look right here, I've got it highlighted, I'm sure you've read it too. The motion to deny conditional use permit by Kima was due to a conflict with the comprehensive plan, incompatible with A2 districts, public health, welfare, and safety, and lack of approved driveway access, character and density, and Village of Webster and the town of Meehan in opposition. I have significant cited case law that negates every one of those things by the attorney of the gentleman that was there. I don't have anything from Burnett County from a legal perspective that is saying just
countering any of this.
correct.
Yeah.
And that boils me, because the emotion, I know everything is there. But if I remove all that, the case in front is whether or not this. And when I read through this Dempsey law, I'll be honest, I don't read the proofs of the sightings of case law, but they're there for a reason. That's, part of the process.
Well, I think there's enough missing here that, I'd make a motion to send the appeal back to the Land Use and Information Committee to redo and reexamine.
I'll second that motion.
Okay, motion made and seconded. All in favor signify by saying aye.
Aye.
Aye. Opposed, same sign. Thank you. Okay, 2102,
A lot of the same.
Shelmo.
Yes, I'm here.
Go ahead, Daniel.
Yes, I'm here.
Okay.
Can you hear me?
Yes, appeal 2102.
Yeah. Yes, I refer to my attorney, Lee Troni, to make my presentation on my behalf.
All right, you.
Hello again.
Yes, sir.
Pretty similar. I just want to start out making sure that, if nothing else, it reads in the record that I submitted all my facts and law. And in this particular matter, there's a Land Use Information Committee packet and their decision and minutes, both dated May 4th, 2021. A Board of Adjustment appeal application and my supporting letter, both dated July 13th, 2021. And then some written comments from September 10th and some emails September 17th and September 20th from 2021. Those were all the facts and law that I submitted for this matter. I trust those were all in.
Yes.
Okay. So same format of discussion from my part. I go to the motion to deny CUP 2108 from May 4th, 2021. And it's fairly similar. It says it's based on correspondence from the towns and the village, and it was based on the general public comments. Then they added in that it was based on waterfront access, having access to the waterfront, and then some very similar reasons that the CUP was not internally conducive to the zoning district that it was available in, density and intensity of use, the general terms detrimental to health, safety, general welfare, economic prosperity, and that's the motion that passed. So again, not a lot of more facts other than what was submitted, and based on that is what I submitted the letter accompanying the appeal. And again, I just go through all the legal points that are cited as a basis for that motion, and whatever else someone thinks should have been decided or could have been decided, that's what's in there. And once again, after some general discussion of the scope of the law, I get into each one of these legal points. Correspondence, and I don't mean to suggest that a municipality's opinion is unimportant. I think it is. But as a basis for a legal decision is a different matter. And it is cited as correspondence from these municipalities is the basis for the decision. I'm not even sure the committee thought that they had any legal weight, but correspondence, writing a letter of your opinion that's just your opinion, is not an element of legal weight into the county administered zoning decision. That's the difference in the law. And just to get it in here again, I'll cite again that M&I Bank, Marshall and Ilsley versus Town of Summers case. Citation is 141 Johnson 2nd 271. And that is a case again where a town was sued that's under county zoning, and that case was dismissed because the town isn't responsible for the county zoning, the county is. So it wasn't an appropriate party, and that case was dismissed against the town. And it just goes to show where the buck stops in this. And it's the same thing with the comprehensive planning statute and other things. It's the county's zoning has to be assisted with the comprehensive plan, but then the comprehensive plan is not a regulation and does not at all need to be a basis in CUP decisions. And they put that in, very specifically at the time that was going on, legislatively, at the state. So correspondence, I just cited, I think, the statute. The correspondence alone is not a legal trigger for a separate body, in this case the county, to cite as a denial of a conditional use permit. And it even says general public comments. I think the law is pretty clear that general public comments are not themselves, I think that's part of the disconnect, necessarily evidence of any kind. The reason we have public input is to find out if there is a concern to explore further. But when it's not testimony under oath or anything, it's hard to argue that it rises to a level of being substantial evidence. And that's, I think, part of the disconnect here. Even tonight, we don't have a second party. We're just having people at a microphone giving public comment, and it's hard to overcome that level of evidence with only that being presented. Waterfront access, I cite the law there, Movrich case. That was a big decision a few years ago. Basically, and some following cases, go to the next page. A local municipality, because of the public trust doctrine, cannot regulate who has access to water and who doesn't, who has waterfront and who doesn't. It's literally not an authority of a local government. And in fact, if you look at the peer regulatory authority, a pier that qualifies for a statutory exemption can be put in automatically. It's a permitted thing. And that's the case that Oneida County versus Sunflower, that confirmed that interpretation of law. The fact is, waterfront access and piers are not a part of the CUP decisions, and the applicant can put in as many piers as he is legally able to do right now, whether there's a conditional use permit or not a conditional use permit, and it's totally exempt from that authority. Next is the incompatibility with A2 zoning. And again, this is a legislatively made decision when the zoning district classification is designed, and this is allowed as a conditional use permit. And you're allowed to make the application. So to say as a blanket statement that it's not allowed in that district would be incorrect. It's allowed because it's in there. And again, we didn't get to a rise of more detail to discuss that further, including with density and character. It's really the same thing. The existence of a conditional use permit to apply for is somehow not legitimate or legal, but it is because the legislative decision was made to put it in there. Public health, safety, welfare, again, Heartland case is cited. Direct legislation or direct case law says that you cannot just generally cite such things. And again, if you look at the minutes of the campground work group that are submitted in the September 10th letter, there's a lot of truth to the matter there, where a lot of people came in to that committee and gave evidence at that time, and it contradicts that there's a safety problem. The assessors specifically contradicted that property values are lowered by the presence of a campground or not. There's really nothing there, is why those facts were submitted. I think that's enough to say when you have public comment alone that says public health safety, and then you have reference to local professionals in writing saying that those aren't really concerns, I think that's enough to defeat nothing more than public comment. Bring evidence in would be a different story. I think that goes through all of the bases that are there. I'm happy to take your questions.
Any questions, Jeremy?
No, I think that
I don't have any questions this time. Thank you. Again, do we have anything from the county or anything that wasn't noted? Okay.
Nope.
Other public comments from other speakers?
I should listen to that, yeah. We should bring up the public comments, and that would be Donald Hamilton.
Good evening, Don Hamilton. I live on Devil's Lake. I would respectfully request that you affirm the committee's decision by denying this appeal. The record of the committee public hearing is clear and accurate. They carefully considered and weighed all the evidence presented for or against CUP 2108. Procedurally, they followed and properly applied the applicable ordinances and legal requirements before reaching their decision. To correct the statement from the attorney, the LUIC never said that the campground was not allowed. They said it was incompatible with the zoning district. That is an incorrect statement. The committee, in the record is clear. It's very accurate. They never said it wasn't allowed. And when it does come to zoning law, if it doesn't say it's allowed, then it's not. Now, there is a conditional use permit, but the committee never said that. So I do want to correct that statement. It's a misinformation. And as far as the details in the ordinances, I understand your concern for that, but I'm a little confused as to what your role here is. Are you here to review and adjudicate the record and the procedures that were made, or I'm trying to figure out why the county corp counsel isn't here, that if you're allowed to entertain his legal arguments here, the county and anyone opposed to this is clearly at a disadvantage. And his argument, in my opinion, would be more appropriate for the certiorari process that the state statute allows him. If he doesn't like the decision, he can go make his legal argument to a circuit court judge who is prepared and trained to make this argument. So I would encourage you to deny this decision. As far as those details, the zoning ordinance lists categories: health, welfare, safety, economic prosperity. The zoning ordinance is clear. The committee did their job. They heard all the evidence and all the detail. They responded to him via their motion in accordance with the zoning ordinance. If Mr. Tironi has a quibble with the zoning ordinance, then maybe that's his legal argument, that it wasn't enough. But they did make their decision based on the zoning ordinance. And in their opinion, the applicant failed to rise to a level or meet the threshold of approving this conditional use permit. So I just wanted you to know that the substantial evidence test is also very important here. When people appear before a committee like that, there is no testimony. The substantial evidence test is evidence that a reasonable person would agree. There is no one that's going to say a campground would have less noise or less dust or less light. The applicant didn't say that. The people that live around these potential campgrounds, it's going to be noisy. There's a reason campgrounds have quiet hours. It's because they're noisy the rest of the time. So a reasonable person, the substantial evidence test was met. It doesn't have to be testimony. And the attorney is incorrect that this stuff is not a legal basis. It's not a legal decision. It's a judgment of the committee. So again, thank you for your time. I'm sorry I'm over, but I would respectfully request that you do not remand this. If the record is clear and accurate, please deny this appeal. Thank you.
Thank you, Don. Sue Hamilton.
Hi, my name is Sue Hamilton. I live at 7158 South Devils Lake Drive in Webster. The minutes of the May 4th, 2021 LUIC meeting accurately reflect why this committee denied CUP 2108. The committee did their due diligence by wading through a sizable amount of testimony from the town of Meenan and Oakland, as well as the village of Webster and the public. They determined that there was substantial evidence the proposed CUP would conflict with the purpose of RR1 and A2 zoning districts. The high-intensity, high-density commercial campground would be detrimental to the health, safety, welfare, and economic prosperity of adjoining and nearby residences and property owners. This campground, this potential campground, would have been in a shoreland district. The LUIC found the CUP incompatible with Chapter 30. And this campground would have been in the town of Oakland, CUP 2108 is incompatible with their 2040 Town of Oakland Comprehensive Land Use Plan, which does not allow new campgrounds within 1,000 feet of the shoreland district. Please uphold the committee's decision to deny CUP 2108 by denying Chelmo's appeal 2102. Thank you.
Thank you. Jerry Krause?
Hello, thank you. And Jerry Krause on Hayden Lake Road, rural Danbury. Haven't moved in the last hour or so. I don't want to restate again what you just heard, and I've sent correspondence to you as well. I had the opportunity to respond, but the public comment period was over in the last appeal. But what the applicant is looking for here is what I call a do-over. The applicant had an opportunity months ago in both of these cases to present evidence that the CUP is substantial evidence, which he failed to do. I don't think this committee should allow a do-over because he failed the first time around. The committee in the first one was a 7-0 vote. This one is 5-1. They're the ones who heard the testimony and took statements. Counsel for the other side would like you to listen to not anything that happened at either one of those, that wants to talk about something that happened at the work group. Statements made at a work group, not at a public hearing. But if you look at the record in this case as well, you have testimony about runoff from the farm. You have the Herzl camp that's been there since the 1940s, I believe, who was concerned about the safety and well-being of their campers. The town of Oakland denied the CUP with a 3-1 vote. A concern about runoff by Supervisor Conroy. He mentions the fact that a land use change needs to be consistent with the comprehensive plan. Changing a cow pasture to a campground is, in fact, that. So I would urge you to not allow a do-over on this one, and to the extent that you have the authority, to go back and revisit your vote earlier. I would have encouraged you to do that. It's just simply a do-over, and the committee who heard all of the testimony and statements and on the record made that decision 7-0, in this case 5-1. Thank you so very much.
Thank you. Rose Catapano?
Hi, I'm Rose Catapano, taxpayer 7154 South Devils Lake Drive. I've prepared a statement. I am very confused as to what happened to the last the appeal 2101 and what's happening here. The Land Use Committee weighed all the evidence presented and came up and appropriately determined that this CUP and the previous one didn't meet the requirements. They're beautiful campgrounds, but not the right place for them. The Town of Oakland's 2040 comprehensive plan clearly states there are undesired uses. No new campground should be allowed in agriculture parcels adjacent to rural residential or shoreland residential parcels. You got 2 there. Another undesired use includes new or expanded manufactured home parks in campgrounds within 1,000 feet of shoreland districts for rural residential and shoreland residential parcels. Should not be allowed. There was significant testimony of the negative impact. It doesn't take a rocket scientist to figure out this CUP alone is 60 campgrounds. Let's say 60 people. 60 people, that's going to have a negative impact on noise. And who wants their property adjacent to a campground? Ask any real estate agent, and they did present, real estate agents did discuss the negative economic impact on the property values. I'm sorry, I'm just very confused as to what your role is in the proceedings that have occurred and new evidence presented by the applicant, and that Burnett County doesn't present from a legal standpoint their decision. Please reaffirm the county's decision, the Land Use Committee's decision to deny Appeal 2102.
Thank you, Rose. Okay, Greg Whitaker?
Hold on.
One sec.
Okay.
Okay, there you go.
Go ahead. Go ahead, Greg.
Hi, Greg Whitaker, live on the Yellow River, Webster Village resident. Again, the LUIC's decision to deny was entirely legally based after careful points of consideration. I mean, it is just insulting, if I can reference the last case, for you to say I'm not comfortable with generalities. It's not your job to make those decisions. It's your job whether this appeal is legitimate. And if you look at your criteria of limitations and hardships and public welfare, it's not your job to feel comfortable. They listen to the legal basis with significant input, and they made a legitimate decision. And I respect that. And that is absolutely disrespectful for you to just say, well, I didn't hear it, and I don't really know, and I'm not really a lawyer. That's not your job. Your job is show me something that tells me that the LUIC didn't do their job, because they did. For legal, for the applicant to say we're just a person with a mic, of course, it's persuasive and it's biased, it's demeaning. Our local government did a great job of looking at the legal basis and their points of consideration, and they denied. And now here we are, you're sending it back to them after they've listened and spent so much time to local citizens and made an accurate decision, and saying, well, I'm not really, I don't know, I can't really tell, I'm not comfortable, I'm going to send it back. That's a terrible decision. And if you send this one back, you will make another terrible decision. Thank you for your time. Know your job. Have a good night.
Thank you. Christina Whitaker?
Good evening. Christina Whitaker, again, a full-time resident on the Yellow River, just south of the proposed campground. Calling again tonight to support the Burnett County Land Use Committee's decision to deny the Chamo Cup 21-08. The April 6, 2021 Land Use Meeting accurately reflected the proposed CUP conflicted with the Burnett County Comprehensive Land Use Plan and was not compatible with the intended use statement of the A2 and RR zoning district. The denial reflected the evidence-based concerns that the CUP presented and how it would have a negative impact on the health, welfare, and safety of the neighboring lands and waters. But more importantly, I think we need to take into consideration that you have the bodies of government, Village of Webster, Townships of Neenan, and Oakland Township all opposed CUP 21-08, reiterating the concerns of the public and the Land Use Committee's decision. The committee determined the proposed CUP was incompatible for the purpose of A2 and R zoning, and the applicant failed to meet the necessary categories that a CUP requires. The record is clear, and we're asking again that you affirm the committee's decision to deny CUP 21-08 by denying Chamo Appeal 21-02. The committee carefully weighed and applied the proper protocol with all the evidence presented for this proposed CUP before making a decision. The committee fairly determined there was a substantial evidence to warrant denial due to the unique problems this CUP presents at this particular location. But I think more importantly, my understanding is that your purpose this evening is to determine whether or not proper protocol was followed with the Land Use Committee's decision with the denial, and the weight of their decision is heavily weighted, and it was evidence-based. We are not here this evening to debate the Land Use Committee's decision, but to reaffirm that the proper parliamentary protocol was followed. That decision needs to be respected. Please deny this appeal. Thank you for your time and consideration this evening.
Thank you. Timothy Stoffel.
I'm here for myself and as well as concerned citizens of Devils Lake. We support the decision made by the original decision made by the Land Use Committee on this 2108 regarding the Devils Lake campground. They properly considered all the input, the facts, and they appropriately determined that the CUP did not meet and conflicted with the comprehensive plan and incompatible with the A2 zoning district. They vetted all the information of hours of people's testimony, sending in letters, etc. So we have to take all the work that they did and give them credit for that instead of having to retry that whole meeting over tonight. That's not what this meeting is for. The CUP does not meet the Oakland's 2040 comprehensive plan. You know, as a proposed commercial campground falls into an undesired use. And this is an undesired use of trying to put this campground within 1,000 feet of the shoreland district for the rural residential or the shoreland residential parcels. It does not comply with or follow the Oakland comprehensive plan. So again, it should fail. We shouldn't even be discussing it. It shouldn't even be allowed. You know, the applicant has also failed to provide any evidence that it didn't impact the health, safety, welfare of the neighbors and surrounding property. Lee tried to bring up and generalize again, and he brought up the working group. The working group has nothing to do with this CUP when it was applied for. Keep in mind, they applied for this CUP to sneak it in right before this moratorium was put out there. So him talking about the working group and all the things that they're working on shouldn't apply towards this. He generalized, again, all this health, safety, welfare, and the economic prosperity issue. And he does that because there was so much economic welfare, and as Don mentioned, the light pollution, noise pollution, etc., that it is a concern for the people. He also demonized the fact that said, oh yeah, the economic impact doesn't affect neighboring properties when the campground is there. I, in fact, presented and submitted information that said there's a negative economic impact of 15% of property values that go down next to a campground. So Lee generalizing things really upsets me because, you know, he generalizes information because he doesn't have the facts to support it the other way. So that being said, there was substantial evidence presented by the public that demonstrated that this CUP has negative impact on the health, safety, welfare, and the surrounding properties. The Land Use Committee appropriately denied that this CUP 2108, and this board should reaffirm that denial. Thank you.
Thank you. Mr. Shumwell's representative.
Yes, no.
Lee?
Lee again. Yes.
Mm-hmm.
Few legal points here. Under section 6.7 of the Board of Adjustments Rules and Bylaws, the body can take administrative notice of any applicable facts and laws. And that's why I submitted what I submitted and confirmed that you guys received it. There's some question about facts and laws being submitted, and those are the ones I submitted. You're able to take notice of those. There was reference to a certain zoning case. I believe the gentleman was trying to refer to the Foresight versus Babel case, BABL. The citation for that is 211, Wisconsin 2nd, 599. I think his interpretation of that case, if that's what he was trying to do, was incorrect. It is true that that case does uphold a ruling that a zoning ordinance that does not allow a use affirmatively means that that use is generally not allowed. The ones that you list that are allowed are the ones that are allowed. Okay? But the fact is that doesn't really apply to this matter because a conditional use permit for a campground was allowed. So I think the Forsyth versus Babel case actually stands for the applicant and not against the applicant. You know, the applicant has to show that he meets the requirements of the ordinances to get his permit. And if you do meet the requirements, you're supposed to get it. And those laws are cited in my letter. You need to show up with substantial evidence to say that despite the fact that you meet the requirements, you still shouldn't get it. And again, we haven't had that. Why is the applicant here in the first place? Because he has the property rights that allows him to apply for that conditional use permit. Why is he here tonight? Because he has a legal right to have the Board of Adjustment review what happened at the committee. Why could this end up in court? Because either party has the right to do that. But that's not necessarily the first choice. Court is expensive. If it wasn't expensive to get some legal advice, the Board of Adjustment would probably have some on the other side tonight, or the committee would have. And I can't answer that question. I cite to those rules because I'm trying to get them to give anyone some legal advice. And the opposition members don't see fit to hire an attorney either. I don't understand that, but it is what it is. This decision should be legal. The committee's decision has to be legal. It's not a legality-free zone. That would be wrong. The government generally does not have a do-over. That is the Heartland case, which I have cited. Government is supposed to take one shot. I think that there's a stronger case, and I would argue for an overturning of the committee's decision, but I recognize that you have options, including affirming or remanding as you see fit, and that is your job. We mentioned runoff. There's a direct letter in the file, which I submitted here, from the county officials that determine that there's no substantial runoff. The idea that a farm of all things, which is not paved hardly at all, and wouldn't be as a campground, the idea that that farm is flooding the entire lake is ridiculous. There's been higher than average rainfalls. That's easy to verify. And the county went out there, did some laser levels, documented that letter, and determined that there's no substantial runoff. So to be arguing about misstated facts that the runoff is a problem, that is ridiculous. That is not the facts. That's why I submitted the facts that I did submit. Comprehensive plan issue, again, we've been over that. It doesn't matter which comprehensive plan it is, but certainly not the town's, is not a veto of a conditional use permit. And that is not just the statute, but that is that M&I Marshall and Ilsley Bank case versus the town of Summers that I mentioned before. There was a reference to a legal standard for a variance, I think. There is an extraordinary standard to meet a variance. This is not a variance. That is a different type of zoning permission. This is a review, an appellate review of the committee's denial of a conditional use permit. So the variance standards do not apply to this matter. Just to clear that up, I think that was confused. Finally, just speculation is not evidence. Showing up and saying you're afraid of what might happen based on your layperson opinion is speculation. And that's why I submitted those minutes from the work group. There's those people, and they're not speculating, and they don't have a problem. That's why it's submitted. So that's for the Board of Adjustment to consider, and that is your job. So I believe those are my comments in reply, and I'm here for any questions if you have any. Thank you.
Thank you. Have any questions, Jim?
No.
No questions on this end. Thank you. With that said, there's no further general comments from anybody. Okay, we'll close that portion of the meeting. We'll deliberate amongst ourselves. Thank you.
Paperwork on the Board of Adjustment rules and things like that.
Hi,
Internet.
yeah, I can,
Can
well.
you pull some up? Or get a-
Board of Adjustment rules,
Yeah, it's clarification, like I said.
yeah. I can get
Like I said, I don't know if this is my fourth month on committee. It's been an interesting ride, but I want to make sure we're staying in our wheelhouse. Because we are citizen members of committees like this, just like elected officials. I was trying to text Wanda, but not good enough to do that, think at the same time.
Oh,
So I have it pulled up on my computer. Yes. Okay.
It's probably huge, but.
It's only 14 pages. It's short for what we.
I'd like one printed anyways in the long run, so that would be handy. Donna?
So with the introduction of neighborhoods and our new zoning in the area or possibly affecting these, it's a different ballgame than we were dealing with before, certainly. I would think the land use committee had numerous amounts of input with from the towns surrounding, certainly, which would be affected. Something wasn't present before. Thousand feet of lake shore, or within the 1,000 feet.
Thank you.
Thank you. not a good time to be going through this.
Correct, but, it's been brought into question, some of the stuff, and I want to clarify as our role. Make sure that we're staying in our thing. Now, under assumption, the way stuff was presented, this committee is set up to see whether or not the process was done right, and their thing, the Land Use and Information Committee come to a reasonable
Right.
conclusion.
Right.
Now, when the committee states conclusions, if those are argued legitimately, they were right or wrong, I would assume that this committee has the authority to say, hey, we find that the case, or is it, like I said, we've talked about this in the past. Let me keep reading.
Give me. I have to think that the town's input to the land use committee for the surrounding towns or anybody affected, plus the prospect of being 1,000 feet or within 1,000 feet of water, also weighed rather heavily on their decision. At least I would think it would. Now, they get the correct information, one has to.
Well, that's you're referencing, I think, the Town of Oakland 2040 plan.
Yeah.
Is what's been stated in testimony.
Almost think that input not relative to the town or the water situation didn't weigh that heavily on the land use committee. I'm sure the health and welfare did, but proximity to towns, the possibilities of the weekend disruptions or whatever, I'm sure that made part of their decision.
Where? Approve, deny, or send it back, Marv, right?
Excuse me,
I said we got three options.
again, right.
Mm-hmm. Don't sound that hard when you say that.
If we take into effect, chapter 30, whatever, impact on surrounding areas, compatibility with surrounding areas, in my mind, putting a campground next to residential areas is not compatible. Been there, done that. Just isn't. Suitability for the area, with the water being an issue, I'm not sure that's good either.
I'm suggesting a motion to approve the denial of 2102. Let them work it out. Mm-hmm.
I would say, I'd say in my mind, the land use committee did their due diligence on this case, but that's, yeah.
I'll make a motion to deny appeal 2102, Calmo.
Okay. Motion made to deny appeal 2102. There's a second to that? Yeah, I second it. All in favor signify by saying aye.
Aye.
Aye, okay, so moved. 2102 is denied, and we move on. Thank you all. Appeal 2103, Webb Lake Area Concerned Citizens.
Okay.
And let's see what we have. Okay. General public?
So, David Graham, the applicant, or the,
Carla Graham, I'm sorry.
David Graham, he's on, he's basically the applicant with David Graham, the one that filed the appeal. He's on remote. Have him turned on right now. David, can you hear us?
Hello? Yep, I can hear you. Thank you. It's okay if I proceed?
Yes.
Yeah, I'm a property owner on Deer Lake and Webb Lake Township at 3647 North Deer Lake Road. I'm president of the Webb Lake Area Concerned Citizens and appearing on behalf of myself and that group, which are two of the appellants here. Thank you for listening to our appeal and your service to the county. I would also like to thank the staff who continues to be a great assistance in helping us as these things come up where we get involved with these processes, so I appreciate it. We appeared before you in August 2020 opposing a similar development at this site and for many of the same reasons opposed CUP 2114. It appears that the new owner is attempting to carry out the North Camp property storage facility plan previously proposed for the site, by the fact that they have not received a new zoning waiver from the town of Webb Lake, or the town of Webb Lake has not approved this new project. There are several reasons for our opposition to CUP 2114, especially without evidence from the developers that will be safe, consistent with long-term zoning goals of the county and providing a meaningful economic benefit to the community. Counsel for Mr. Hubler, the developer, has put in new evidence to you, which of course you consider, but some of which was not presented to the Land Use Committee and Information Committee. The first and one of the most important reasons we oppose the development is the increase in traffic from various campground and other developments. It has been cited as a factor frequently in the board denying various stuff. This intersection in particular is notorious for being dangerous. The previous owner of the property was in fact involved in an injury accident there. In spite of this, neither the previous owner or the current owner have carried out a traffic impact study to address this concern. So evidence that it's unsafe has not been contradicted. The Webb Lake Men's Club created a wonderful 7-mile bicycle and hiking trail called Dogtown Trail. It previously ended on Deer Lake Road, just short of Highway 77. In the spring of 2019, the club connected this trail to the 6.5-mile Bear Lake Bicycle and Hiking Trail. These two trails connected this intersection of Deer Lake Road and Highway 77 and Bear Lake Road. We now have pedestrian and bicycle traffic in this already dangerous area, which greatly increases the risk for serious accidents at this intersection and on Deer Lake Road, which has no warning signs on it for the increased traffic. Now the sponsor of Cup 2114 wants to add storage, boat storage and servicing to this already dangerous intersection with boats, haulage vehicles, when vehicles with long and wide loads added to the mix, the increased pressure on this already dangerous intersection in Deer Lake could be significant, if not lethal. The traffic on Highway 77 is currently heavy, especially during summer months, with cabin and campground people arriving, and most, if not all, exceed the posted 55-mile-hour speed limit. The major problem is the visibility from traffic on Highway 77 as they approach this intersection. Traffic from the east involves an uphill grade on a curve, so traffic entering Highway 77 from Deer Lake Road is blocked from view until reaching the crest of this grade. A similar grade on Highway 77 for traffic from the west poses the same risk. You don't have to take our word for it. This is not just opinion of people that live in the area and concerned about the issue, but the state of Wisconsin Department of Transportation has looked at this intersection. Their study noted this is a quote, it is the case that injury crashes do make up a higher proportion of crashes, 42% in this area, than they typically do in all statewide crashes, which is 23%. Clearly, no one except those objecting to Cup 2114 has thought through or studied the traffic impact of this project. If one accident, especially a serious one, can be prevented, it's worth re-looking at the traffic situation. In addition, there's increased ATV traffic on Deer Lake Road, which would be negatively impacted by the additional boat hauling traffic. While the operation of the facility is somewhat seasonal, it is still disruptive to the neighborhood during the 4 busiest months of operation. Environmentally, the second reason we oppose this is the site is on top of the watershed for Webb Lake and Jones Creek, which flows into Webb Lake, and they should be protected. Lakes and streams bring people to the county, not storage businesses. There are plenty in the area. Periodic oversight should be required to ensure that holding areas and other environmental protective measures are working, and those environmental protective measures will be required by the DNR. So we need to make sure that to the extent this would ever go forward, that somebody actually keeps track of what's happening. And as far as the zoning goes, clearly the parcel is spot zoned in a manner inconsistent with the comprehensive plan. The land on which this project is to be built sits on a lovely wild area of the county. A fenced-in storage yard is not nice to look at, even if you cannot see the boats behind the fence. The project is not significantly improved by trees and vegetation. The people who live in the area do not want this type of facility in their neighborhood. The town of Webb Lake year 2030 comprehensive plan and the Burnett County comprehensive plan have a vision to maintain the natural beauty of the landscape and rural character of the land and preserve and protect natural resources. It expresses a desire to concentrate commercial development within hamlets like Webb Lake. These plans were created to meet the requirements of Wisconsin's comprehensive planning law, Wisconsin Statute 66.1001, which states that document also states, and I quote, "New development should be placed on the landscape in a fashion that minimizes potential negative impacts to Northwood's character as defined by locally significant landmarks, scenic views and vistas, rolling terrain, undeveloped lands, farmlands, and woodlands, aesthetically pleasing landscapes and buildings, limited light pollution, and quiet enjoyment of these surroundings." In addition, there's plenty of space in more densely developed areas, including in and around the Webb Lake hamlet. So I would ask the committee to consider that in making their decision this evening. Finally, the Webb Lake area concerned citizens tried to negotiate a purchase of this land, but these efforts were thwarted by the refusal of the previous owner to negotiate with us in that attempt, so we could use it for something that is consistent with the zoning vision and land use vision of both the town of Webb Lake and Burnett County. For these reasons, and also for those in our submissions that we made, which I'm not going to repeat, which you gotten enough in advance, I will not go through that again. I urge you to reverse the decision of the Land Use Committee as to CUP 2114 and support Appeal 2103. Thank you. If you have any questions, I'll try to answer them.
Thank you. I don't have any questions, actually.
Thank you. Thank you. There's no further questions at this point in time. Thank you.
Mm-hmm.
Anyone here in the audience? Yes.
I'm Carla Graham.
Okay.
No relation to David Graham. He was on the same way.
Well, long evening for you guys, so really appreciate, I want to thank you in advance for your time, your consideration, and also your service. My name is Carla Graham, and I'm a property owner on Deer Lake. My address is 31311 Deer Lake Road, and that's East Deer Lake Road, which is a little bit less than a mile from the proposed property. The adjoining property, my property has been, so I've been around for 54 years in that same spot. Our lake home sits 150 feet from East Deer Lake Road, and again, less than a mile from the proposed business. I'm also a Webb Lake area concerned citizen. So there's several reasons for my opposition to CUP 2114, and I'm going to talk about a couple of things on a Mr. Hubler's position statement that I received recently regarding economic benefits and then traffic if possible that time. Mr. Hubler testified about the need for a pontoon boat storage business, shared a personal story that he had about finding no availability for storage one winter in the local area. So he stored his boat in Washburn County, and this inspired him to create this or to build this storage business so that he could bring it local to Burnett County. Well, there's other boat storage in the area, and I have talked with them. Northern Lakes Marine, A&H Boat Storage, and Maine Boat Storage in the local area. And the information that they have given me between their indoor and outdoor storage, they have never filled up. They have never been full. They have room to store more boats. So since there's availability at current storage businesses, what is the positive economic gain here? You know, why are we, building another storage building if there's already space available in the current one? All you're going to do is get customers moving between the two different businesses. Mr. Hubler stated that paying employees at his business will put additional dollars into Burnett County and the local economy. Is Mr. Huber, I'm sorry, I keep pronouncing your name wrong, is Hubler, correct? Hubler, okay. So I want to make it correct. So unless Mr. Hubler makes living in the area and spending the money in the area a hiring requirement, there's no guarantees on this benefit. Mr. Hubler also stated that instead of property owners storing their boats on their properties in the winter months, they would be consolidated at his business. There's currently space to store their boats already, so if they wanted to do that, they could, but I'm assuming they don't want to. And I also find it interesting that when we drive around here in the winter months, all the boats that are sitting outside are on the campgrounds. So they are the tourists. They are not the property owners. So multiple times under the economic prosperity that Mr. Hubler has referenced, sorry, do I have a little bit more time? Yes, I'm close. Thank you. Mr. Hubler's referenced tourists more than property owners throughout the whole position statement. And so as he referenced, he does tourist-based service that he's providing. Seasonal visitors furthers tourism. It serves Burnett County's tourism. There's seasonal tourist-heavy economy. So it seems to me that this business is more in support of the tourists and providing them storage than it is for property owners who pay for the taxes for the town and county boat services. And I just want to let you know, David Graham mentioned the intersection Highway 77 and Deer Lake being hazardous. On May 29th of this year, 7 ATVs were involved in a crash at the intersection with 4 individuals going to the hospital via ambulance. So that's something that David Graham was not aware of. So anyway, and again, you know, if Mr. Hubler routes the boat pickup from Oak Ridge boat landing on Webb Lake, he will go by Deer Lake Road constantly because it's the back way, it's the shortest route, and it avoids Highway 77. And so let's say he takes out 100 boats coming from that landing twice a year. That's a total of 200 trips in the spring and fall. That goes 150 feet from my cabin where there's already ATVs, cars, trucks, trailers, campers, people biking, people walking. It is hazardous. It's a danger. I have almost been hit head on, and I've had to go off to the side because people come over around the curves, over the hills, and I end up going over on the side of the road because they're going too fast. So it is a very dangerous place and just waiting for accidents to happen. So I urge you to reverse the decision of the Land Use Committee for Cup 21-14. And thank you for your time and allowing me to go a little bit over.
Thank you.
One more here.
We got one person on the board.
Janine Joseph.
Yes, can you hear me?
Yep, go ahead.
Hi, yes, so I'm Janine Joseph. I am the property owner right across Deer Lake Road from where this proposed boat facility is. I have a few things to say. First of all, I was never made aware that property was being, the zoning was changed from rural to commercial. I did that research before I bought my property and quite frankly, put my life savings into building my dream home over on Thatcher Lake. So I'm very unhappy with that. If I would have known that property was for sale originally, I would have been very interested in purchasing it. I was very interested in purchasing it from the first fellow. He was not willing to work with us at all. I wanted to purchase that land and I wanted to turn it into a park for the area. I have been up in this area. My grandfather built a place on Deer Lake in 1950. So my family's been in the area for over 70 years. We have 4 generations of people with multiple cabins in the area. So I'm on Thatcher Lake. We have my grandfather's cabin still on Deer Lake. And it's been a tremendous concern to see the destruction of this land. I feel like people who live there are not really aware of how unusual it is. And once it's gone, it's gone forever. And I feel very bad that we're even talking about it, the land and the water, the overuse. There's a lot of negative things that are happening in the area because of these efforts to turn it into some kind of, you know, ATV heaven, some kind of boating heaven. And the people who live there, honestly, I don't feel like we have a voice in this. I have been listening to this entire meeting, and I have heard an awful lot of people speaking about their concern for the land, for the water, for the area, to retain the natural beauty. That's what's important about that area. And it doesn't seem like we have representatives who are willing to hear us. You know, we are generations of taxpayers. We are generations of people supporting the local businesses. And I don't feel that we really have had a strong voice in this. And that's it's not a good feeling, as I'm sure you can imagine. So I would really like to make sure that you're hearing the other side of this from, you know, the family situations, the generations, the love of nature, and the, you know, the respect that many people have. And I would like that really to be taken into account. There's more than just finances involved in this. So like I said, I just feel like once this is gone, it's gone forever. And I feel like we have an opportunity to save that and restore the beauty of the area rather than continuing to destroy it. And that's really what has been happening over the last few decades. So I really hope that 2103 is something that you take into consideration and pass.
Thank you. Anything else from the county or anything?
No, I think we still have Mark, we still have a couple of more people that haven't spoke yet, but still signed up yet. So we have Mark Krause, Saunders, and Mark, I believe.
Yep. Nice to meet all of you. I'm Mark Hubler. I am the owner of that property that we're referring to. Nice to meet all the Grahams, even though they're not related. Look, there's a few things that I would like to address personally. And then I'm going to turn this over to my attorney who is here with me today, as well as Mark Krause, who can speak to the engineering that was requested as a part of this build. Like everyone that's spoken, I too am a long-term resident here. I have owned a home for 13 years. My mother's 87 years old and has had a cabin here since I was 5 years old. We have 5 family cabins in the area, and we love this area as much as anyone else does. As they say, necessity is the mother of invention, and that is exactly how this started. I did buy a new pontoon, and I found myself in Spooner to drop it off and store it for the winter. You're right. I think I could find storage here in the area, but I wanted storage that I could trust, that wasn't animal infested, wasn't open to the weather and the elements. And every one of us has been in downtown Westlake and seen what a disaster some of those competing businesses are, and that's not the intention at all for what this is. I think this is the third appeal as it relates to this property. It's interesting to me as I learn my way through all this as a first-time independent business person. You know, this comes very late in the process. Later than I would have ever imagined that an appeal could come. I'm $100,000 into the work. I have $300,000 committed. As a result of this appeal, I've had to go back to people and tell them that I can no longer store anything for them this winter because I've had to delay much of the work that I needed to do. It is true that this is a business, and we expected to do somewhere between $60,000 and $80,000 of revenue this year. And you're absolutely right. No tax revenue now, no paying people, no employment and lost wages as a result of that. I'm not running the North Camp property storage plan, which is what Mr. Graham suggested. I don't know exactly what the North Camp property storage plan was, but I was very clear in my presentation that this is about boat storage, and it is not about having individual units with people's life savings inside of them. That's not the storage that I choose to run. Last, like I said, personally, I've learned a lot in this process. Admittedly, a bit somewhat amazed. This is a 10-acre piece of dirt that I don't know, Mr. Crowley, I'm sure can answer the question, that we're taking down one tree as a result of the work that we're doing. This property was cleared years ago by the state when they redid the highway. It literally is a piece of dirt on a highway. It's zone commercial 1. There's many things, is that the right, am I saying that the right way? There's many things I could do with this property, restaurants, bars. That's not what I want to do. I don't want that type of a business on that street corner. And last, on a personal note, very personal note, I'm being honest when I say I'm a bit frustrated by the group that represents itself the way they do. Mr. Graham is an attorney practicing in the state of Minnesota, and he's sent me personally information Not suggesting that he is an attorney in the state of Wisconsin, because he's not, but it's been on letterhead and it's been directly to me as an individual, which we all know is improper in terms of how to deal as an attorney or not. Not suggesting that raises to the level of being disbarred in his state, but it certainly is bothersome personally to me. So now I'd like to turn this over to my attorney.
Sit up there. I won't bite.
Okay.
We might.
No guarantee.
I think just to clarify, since we're providing the rebuttal, I think we're allowed more than 3 minutes.
Yeah.
Talk more than 3 minutes. Good. Well, again, my name is Anders Hellquist, and I actually did grow up in Birchwood. I didn't come from the Twin Cities, and I practice down in Eau Claire now. So, gotta say, one of my first jobs was working at a bait shop over there. I would never imagine that I would be dealing with the controversy over a boat storage facility in a place like Burnett County, but I guess I've kind of come full circle. I heard folks there in the bait shop, and I'm serving Mr. Hubler as a property owner and a business owner, or future business owner here. So thank you again for your service. It's been a while. You're seasoned. I think that's what they say. And then Mr. Gronsky, thank you for stepping in. I understand you're a little bit newer on the Board of Adjustment, and so there's those new standards and new requirements that you have to look at. So in terms of the record that you have, I think you've received the full application packet that the committee had, which included the PowerPoint and the site layout. I think you've also received the minutes from the committee meeting where they unanimously approved this. And then I had also submitted a position paper on behalf of Mr. Hubler, providing a roadmap for this board if you choose to affirm the committee's conditional use permit. You know, Dave Grindell is not here tonight, so in a way, I don't want to say I'm stepping in his shoes because I wouldn't try to do that. But in case you have any legal questions on what the committee did, I'm here to support the committee's approval here. So I hope Mr. Grindell's absence won't be used against Mr. Hubler. So, you know, I think we really have two requests here. One is we request that the board, respectfully affirm the committee's unanimous approval of this conditional use permit. It was a 50-minute hearing. They heard Mr. Hubler's and Mr. Krause's presentation, providing substantial evidence about the site and the protections that would be there. And the committee also engaged in extensive discussions looking at the traffic issues, looking at the potential stormwater or environmental questions that arose. And they determined that those things simply weren't an issue for this site, or that they could be adequately addressed with conditions. So we'd request you affirm the committee's decision. And if you're going to do that, we provided that roadmap for you on pages 14 and 15 of our position statement, where you as a Board of Adjustment, as you know, when you're basically hearing the same or substantially the same evidence, you can use these, what are known as these certiorari review standards. Did the committee act within its jurisdiction? Did the committee act according to law under county ordinances and state law? Did the committee exercise its independent judgment? And did the committee have evidence or substantial evidence on which to base its decision? We ask those questions, and we show, and we believe that if you make the motion to affirm the committee's approval, that you can just follow this roadmap, and that'll provide you the nice legal basis to have a defensible decision in case Mr. Graham decides to appeal it. Mm-hmm. I went through the 8 all them arguments that Mr. Graham made in his appeal. I guess I know what's on right now, and I also know that you've been here for a while, but did you have any questions after looking at my position statement about Mr. Hubler's positions or the arguments we were making there?
Oh, this one's pretty easy to me.
From what I saw, you had couple of permits to obtain, a permit plus, or maybe two permits, I don't remember off the top of my head. But you were in the process of doing all of those. You were doing everything you had to do. And I believe the surveyor had laid everything out. You made one change, you increased the sizes in storage buildings or something?
Yeah, I think there was a slight adjustment on the size.
20, you went to 20 feet or something rather than 16 or whatever. And you're over like 350 feet away from any water. And the only thing I remember seeing is you had to be, if you were within 300 feet, you had some more hoops to jump through. So I guess in my mind, I don't know what you're missing.
We agree with you. We don't think we're missing anything right now. And in fact, Ruth King from the DNR issued the stormwater permit for construction for this site. So the DNR has reviewed it at this point. It's okay. And then, so again, we're required to, or Mr. Hubler's required to follow all county and state and federal laws here. That's a condition of the permit. So that's a pretty tough standard and a high standard that
you're also following, if I remember right, you're going to be planting trees, et cetera, and screening the area. I'm just trying to remember what was.
Yes. Mark, did you have any other detail on that?
Yeah, we'd be screening areas. We want to get the stormwater erosion control plan first because with the retention areas and so forth, our biggest problem is you get things to grow because there isn't going to be water on the site. We, in fact, part of the retention area discussion with the design was the sand was too sandy or too porous. And so we're going to have a hard time holding water in. So we have to make retention ponds to hold water that won't hold it because it will soak in so fast. So that's, part of the questions we had as far as the preliminary review and approval with Food King. And once these storage areas get built, then they can start the planning plan. That will be reviewed by
Is the whole site fenced, secured?
It will be. Yeah, so the intention is to secure the whole site. I don't know that was a condition. I don't remember that being a condition.
No, I was just asking because they were talking about the frontage on 77 as the condition, and they were arguing over clarification of height for the screen, and those issues hadn't been addressed yet. But the reason I asked is the assumption is if you're going to operate a proper business, the chances are you probably are going to end up, that's the goal of the facility, is to have gated access so you don't have
security. Yeah.
Correct. And I just wanted to see if there's any more clarification if we've decided on that height issue first off, or because on the hill there, you're I don't know how the sidewalls, there's what, 200 by 300 if I remember buildings? 2 by 60. And what's the height? I assume probably 16 or 20. So if you've been to the site, that's just on a hill anyways. Sure. So if you're thinking that we're going to initiate a screened-in fence that's going to hide the buildings, I would think that would be a pretty stupid assumption from the logistics of what it is. It's a storage facility on the highway. It's in a zone commercial district. I don't have an issue with it from a perspective of, it's more, that's going to be the owner's safety for keeping the site safe. We could do that as a condition, but I don't, what's your thoughts on that, Marv? I mean,
I hear a lot of stuff about traffic at that intersection, how dangerous or whatever. Before we were on the board originally when the other gentleman who was the owner came in before you. And if I remember right, they had run a traffic survey from the year, I want to say 2005 or maybe 2007 or something through 2021. And they only had one possible personal injury accident there. The 7 ATVs that Mrs. Graham came up with, I understand they were all underage and illegal drivers. And so, you know, when I look at traffic statistics or whatever, you got to look at how it's being presented, because sometimes it's not what it seems to be. So that's my only comment on the traffic. But I used to own property out there, so I know what you're saying. And but so far it's been relatively a safe intersection, theoretically. And what's going to change when there's more truck, I can't tell you. But and I think that's something that you know, proper noticing on the intersection, or I know coming over that hill and going by the restaurant or whatever, I mean, everybody's going full bore. I agree with you on that too. So yeah, that's a tough situation, but so far we've been lucky.
And the highway commissioner did look at this intersection with, I believe it was Supervisor Awe, before the hearing, and he, I quoted it in my brief, so I'm going to paraphrase it now, but he didn't see any issues with this use at this intersection in a commercially zoned area.
Mm-hmm.
Yep.
Comes up to a state highway. There's, when you talk about deaths per thousand, there's a metric that the state has to meet before they'll even do anything. When I chaired infrastructure, we couldn't get roads made safer because they didn't meet the requirement, even though we thought they did. And there was significant damage. So it's above and beyond the dynamic, but it's something to consider. Yeah. And
the other thing through the last stop sign is 12 miles away. So, you know, somebody's got their foot on the gas, so whatever. But regardless. Okay. I don't think we've got any more questions, do we, Jeremy?
I don't.
Okay.
Thank you very much.
Thank you very much. Appreciate it. We'll close that part of the meeting and deliberate amongst ourselves. Looking at the background of this and having been involved a little bit a long time ago, or seems like a long time ago, you see the gentleman is filling out the proper permits or going for the proper permits. His plan for screening and whatever would seem, I would think, adequate. Eventually, doesn't happen overnight.
Well, you know, that's, the staff comments were about that, and I don't know, Jason, you and I input on that. I think your comment was staff fencing should go from the north property line to the south property line and along the east side, the outside storage area, to screen some of those traveling westerly on State 77. And that was never addressed on the initial, I don't believe, was it? Sorry to throw you under the bus there.
It's all good.
I don't know how long the front is there.
So that comment was,
May 25th, 2021.
yeah, that was saying that from the north property line to south property line on the east side of the outside storage area to kind of view it. So if you were traveling westbound, coming up there, you would see it. What my thought was on that was screening on the east line.
Oh, okay, that's the Webb Lake side. Yeah.
When you're going westbound, you come up that slope, and I think
Yeah.
you kind of see it kind of
Yeah.
up on the hill there. That was my comment, but I don't believe the committee, like you said, did anything with that.
You know, and that, because I know there was multiple times where the height was talked about and back and forth, and that's when we visited the site. I'm like, it's a unique, you know, circumstance. So have you looked into fencing through the thing? Like, you know, I don't know what a standard security fence, if it's 10 feet, 8 feet, you know, deterrent fence that you call most of your areas, but I mean.
We've looked at all of that. We haven't made a final determination yet, pending all of this. You know, I think it is your comment. You'd have to put up a fort probably to completely cover every single thing. That would be the difficulty. So I think the standard fences on most of these types of properties are somewhere between 8 and 10 feet.
That seems logical to me.
Question, what about lighting? What are we going to be seeing from the road?
Yeah, we, again, I don't believe that was specifically addressed, but what do you call that? The downward.
Oh, yeah, okay.
Yeah. As far as on the east side, you're talking about that hillside, that was logged before they bought the property. And so the hope is to let that hillside naturally grow up other than where the retention area is.
Yeah.
And that will grow back up, and so hopefully naturally there'll be trees growing on that hillside that will help hide this better than anything else that we can do as far as artificially.
Another dumb question, but are you going to have alarms?
Yes.
Okay.
On the building, so.
All right.
Probably end up being motion.
Okay. Will we be able to hear them in Wood Lake?
I'm on Web Lake, so I'm not. My phone goes off.
Okay, just wondered. Do I remember right in seeing some kind of an enclosure, a building like a general office building or something, or?
Yeah, a shop.
Okay, shop, okay.
Is to do winterizing as well. So the boats would pass through a shop to do that work and then get parked in a storage building. That would be the intention.
Okay.
I have no further questions or concerns. We don't, until it gets closer.
I think it's pretty well covered, I would think.
Let's make sure we word this right.
Don't see any big problem with this, do you?
No, I'm just trying to make sure, because it's an appeal, so I think a motion to affirm the conditional use, or the Land Use and Information Committee, conditional use permit 2114 would be an appropriate terminology, which means we're going to affirm what Land Use Committee did by approving the thing.
Mm-hmm.
I know we're not supposed to make negative motions, at least I heard that one. Otherwise, it's a motion to deny the appeal. Jason, have you had that happen?
You can probably word it either way.
Okay.
Well, I started with that. Motion to affirm decision made by Land Use and Information Committee in reference to conditional use permit CUP 2114.
Okay, motion been made to affirm 2103, and use permits CUP 2114. I'd second that. All in favor signify by saying aye.
Aye.
Aye, opposed, same sign. Thank you.
Weird. Yeah.
Okay. We have some previous documents to sign this time.
Yeah.
Goody. Thank you all.
Thank you. Lorena's, hopefully that big front is all done.
I hope the Packers are winning.
Well, that's right. What the heck?
Yeah, I don't know why you guys.
Not good, I know that.
Well, I was looking at my phone, but I was trying to text Wanda to get information.
Do you want to adjourn the meeting?
It didn't start well.
Motion to adjourn.
Got that one.
These are this meeting.
Thank you all very much.
Appreciate it.
Well, I killed the.
Are we adjourned then?
We are, I made a.
There'll be a motion to
adjourn.
adjourn after we sign the,
Oh, okay.
documents, okay?
Yep.
Oh, boy.
Got a lot of them.
Oh, yeah, okay.
Can we do that after?
Well, let's see here. So we got this first one. This was the addition on North Sand Lake.
Gotcha. Right. Okay. One down.
Yep. And you want to sign as secretary then?
Oh, yeah, I'm the only one here.
The secretary that
This
day.
is the,
This is the garage on Beach Street.
oh, okay.
No date needed,
Gotcha.
just sign and
You
go.
don't date it, yep.
Good.
Okay.
Then go. I finally just put up an antenna again so I can watch actual TV. It's been probably 10 years. But it's annoying when I do want to watch a football game, but it's like I've kind of lost interest over the last year.
Yeah.
Jason, how long you been with Sonic?
Long.
He didn't tell me about it. That's good.
Let's see, Espelon, that is
This
the
one
one
is
that's
the,
on, yellow, little yellow lake there.
oh, this is the reduced wetland setback, yeah. Yeah.
Yeah, we're live. I should get my beer out. I never need to want one. Yeah, there you go, Wanda. I owe you one. I think we could determine that.
That is the garage on Old 35 that he built.
Oh, the guy
Builder.
built next to the lot line, or?
Yeah, builder told him not to get
Yeah.
on there.
Living on one, okay.
We don't have a good.
This one, Stockholm Sports Court.
Oh, yeah.
Pickleball. Yeah, we got a free lifetime membership there, you know.
Yeah.
Right.
Oh, it should be page 3.
Okay, I just want to make sure.
Yeah. Went too far again.
Go too far again, okay.
Yeah. Pages stick together.
Oh, there we go. Gotta remember, these pages used to be about 3 pages next to the end of them.
Yeah.
That was before attorneys got involved.
Yep. Now it's hundreds of pages.
Sorry.
That one is
Webb Lake?
retaining walls, Webb Lake.
Oh, yeah. It's the guy with the neat hill.
Yes.
Oh, right. Oh. Okay. Have a motion to adjourn the meeting?
A second.
So moved. All in favor, aye.
Aye.
Opposed, same sign. Oh.